Jefferson County Court at Law number 2 is now in session with the Court of Raymond docket on today's date of November 29th of 2022. First of all, ladies and gentlemen, I'd like to welcome you to County Court at Law number 2 and happy holidays to all of you. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. Now, our first order of business, I need Mr. Donald Lewis Lamar. Would you please come forward? You're gonna stand on the X.
Okay.
Here you go. Okay, now, Mr. Lamar, the state has elected to dismiss your case. Is that correct?
That's correct, Your Honor.
Okay, so you're free to go, and you have a blessed day.
Thank you. You guys have a wonderful.
All right, you got to go through that door. You can leave that clipboard on the table. Okay, his case was dismissed. The first guy, Mr. Donald Lewis Lamar, he just left. Now, ladies and gentlemen, today our docket is an arraignment docket. And basically what the arraignment is, it's an opportunity for the court to tell you what you have been charged with, what your rights are, and what your options are concerning your case. You have been charged with a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. The difference between the two is not only the nature of the crime, but also the range of punishment. And what I mean by the range of punishment, what I'm referring to is what you can get as punishment for the charge. For example, if you had a felony offenses are divided into 5 categories. The highest category on down, you start off at a capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you are convicted of a state jail felony, your range of punishment is a minimum of 6 months in the state jail, up to 2 years in the state jail, and a fine up to $10,000. For conviction on a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine up to $10,000. Of conviction for a second-degree felony, the range of punishment is a minimum of 2 years to a maximum of 20 years, and a fine up to $10,000. A conviction for a first-degree felony entails jail time from a minimum of 5 years to a maximum of 99 years to life, and a fine up to $10,000. A conviction for a capital murder is either life or death. That's the punishment. Now, your misdemeanor cases are divided into 3 categories. You have a Class A misdemeanor, which is the highest, Class B, and a Class C misdemeanor, which is the lowest. For a Class C misdemeanor, you cannot be given any jail time. The range of punishment is a fine only. However, if you do not pay your fine, you can be given what is called a capious pro fine, a warrant could be issued for your arrest for you to sit out the time on your fine. The next highest misdemeanor is a Class B misdemeanor. The range of punishment is 0 days to a maximum of 180 days, which is 6 months in the county jail. And you could be given a fine from $0 to $2,000, or you could be given both such fine and confinement. For a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is from 0 days to 365 days, which is 1 year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is your right to have an attorney. The clipboard that you have been handed out mentioned or talked to you or informed you of your right to have an attorney. Now, regarding your right to have an attorney, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. That means that you'll be given another court date so that you can hire an attorney. If you want an attorney and do not have enough money to hire an attorney, you will need to fill out a financial questionnaire so that the proper person can determine whether or not you qualify for the appointment of a court-appointed attorney. Now, if you would like to represent yourself, in essence, if you would like to waive your right to have an attorney, give up your right to have an attorney, you may not speak to the prosecutor about your case unless you sign a written waiver. A waiver is you signing or waiving your right or giving up your right to have an attorney to represent you, and you're desiring to represent yourself. And so if you want to speak to a prosecutor about your case, you cannot speak to the prosecutor, and the prosecutor is assistant district attorney, and we have one sitting in court at that table in front of you. It's Attorney Lamar Johnson. You cannot speak to him if you want to, unless you sign a waiver of your right, giving up your right to have an attorney and desiring to represent yourself. So if you want to represent yourself, you sign the waiver, you'll be allowed to speak to the prosecutor about your case. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including a loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. So at the bottom of this document, or at the bottom of the document that you have, it states, defendant's choice, mark initials next to only one choice. So if your choice is, I want to reset my case to hire my own attorney, then you'll place your initials on the first line to the left. Now, if you have already hired an attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for a court-appointed counsel, a court-appointed attorney, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, which means to give up your right to an attorney and represent yourself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, November 29th of 2022. Now, for those of you who will be giving up your right to have an attorney and waiving your right to have an attorney, and those of you who will be representing yourself, you will need to read and sign the second page that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And I will go over this document with you, and it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 29th day of November of 2022 by the County Court of Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, you will sign your name above the line that is titled defendant, and you will place today's date, November 29th of 2022, above the line that is titled date. Now, as a defendant in a criminal case, you not only have a right to have a trial, you not only have a right to have an attorney, but you also have a right to have a trial by jury. When that young lady is sitting in that area, we call that the jury box. 6 citizens will be selected to set it on your case. After listening to all of the evidence in your case, and after deliberating, they will decide whether or not you're guilty or not guilty. You also have a right to waive, which means to give up your right to have a trial by jury. And by doing so, your case will still come before the court in one of 3 ways. One way your case will come before the court is by way of a bench trial. A bench trial is a trial before a judge only. The judge will listen to the evidence and the judge will decide whether or not you are guilty or not guilty. The other way that your case will come before the judge, if you decide to waive or give up your right to have a bench trial, it will come before the judge by way of an unagreed plea bargain. What an unagreed plea bargain is, it means that you and the state have not been able to reach an agreement on your case. Therefore, you would like the court or the judge to decide what your punishment will be in your case. The other way the case can come before the judge is by way of an agreed plea bargain agreement. An agreed plea bargain agreement means that you and the state, then when I say state, I'm talking about the district attorney's office. You and the district attorney or the state have been able to reach an agreement, and you would like that agreement to come before the judge and see if the judge is going to follow your plea bargain agreement. Now, the court or the judge does not have to follow your agreement. If the judge does not follow your agreement, well, if the judge does follow your agreement, and if you decide within 30 days that you would like to appeal your case, what an appeal is, if you believe that you've been wrongfully convicted or the court committed an error by convicting you, you would like to have an appeal, you would like to have a higher court to look at your case. That's what we call an appeal. That higher court is located right above us. It's called the Ninth Court of Appeals. They will review your case. They will decide whether or not you're guilty or innocent after listening to all the evidence. If they believe that, or if they grant your appeal, then they can simply find you not guilty, or they can give you what we call, they can send the case back down to this court and order this court to give you a new trial, a whole new trial. Now, if the Court of Appeals, the Ninth Court of Appeals, deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can file what is called a pro se petition for discretionary review. Pro se means without an attorney. In essence, you'll be filing on your own behalf a petition to the highest court, the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals, which is located in Austin, Texas. Now, if they grant your petition for discretionary review, they could either find you not guilty, or they could send the case back down to this court, or to this court to give you a whole new trial. If they deny your petition for discretionary review, then at that point, your conviction will stand. Now, just to recap, you have a right to have an attorney. And in regarding your right to have an attorney, you can hire an attorney. You can see if you qualify for a court-appointed attorney, or you can waive your right to have an attorney and represent yourself. You also have a right to have a trial by jury. You can waive or give up your right to have a trial by jury. And by waiving or giving up your right to have a trial by jury, your case will come before the judge in one of three ways: either by way of a bench trial, that's a trial by judge only, or it can come before the judge by way of an unagreed plea bargain, which means that you and the state have not been able to reach an agreement concerning the settlement of your case. Or it can come before the judge by way of an agreed plea bargain, which means that you and the state have reached an agreement to settle your case. Now, you also have a right to have witnesses that come to court. And where this gentleman is sitting in this chair, we call that the witness stand. And what witnesses do, they can either testify for you or against you if you represent yourself, or if you have an attorney to represent you. They can ask questions of the witness. We call that either direct examination or cross-examination. Now, you also have a right to give up your right, or to waive or give up your right to have witnesses that come to court. Now, by waiving or giving up your right to have witnesses to come to court, that simply means that you will not be calling witnesses to testify in your case. It does not mean that the state or the district attorneys will not be calling witnesses to testify in your case, because they will be calling witnesses to testify in your case. Now, you also have a Fifth Amendment right against self-incrimination. And what that means, you have a right not to testify against yourself in your case. And if you elect that right, then the state or the district attorney's office cannot force you to testify against yourself in your case. A lot of times we hear the term, I take the fifth. What that means is I'm not saying anything, I'm not testifying, I'm not saying anything. And so that's what they mean by when they say I'm taking the fifth. Now, you also have a right to waive or give up your right to the Fifth Amendment, which means that if you waive or give up your right not to testify, that means that you will be testifying in your case. Now, you also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you. You have a right to see the documents, you have a right to see videos, witness statements, instruments, whatever objects, whatever evidence the state has, you have a right to have access to that. Now, you can waive or give up that right as well by saying that you do not want to see the evidence that the state has against you. And if you do that, then you will not have access to the evidence that the state has against you. Now, everyone in here that's here for arraignment, you have been arrested. And however, you are out on bond. You're out of jail on bond. And you either out on a cash bond, which means you pay the full amount to get out of jail, or you're out on a surety bonds, which means that you paid a bondsman and you paid that person a percentage of the total amount of bond to get out of jail, or you are out of jail on what we call a PR bond, which is a personal recognizance bond, which means that you did not have to pay any money to get out of jail. However, you did have to promise to appear in court. Now, every day that you have spent in jail on your case, you can get credit for that time towards your punishment. So, for example, let's say you spent 5 days in jail and you bonded out, and you and the state are talking about trying to reach a plea bargain agreement, and the state is offering you 5 days in jail. What that means is you would not have to spend any more time in jail. Why? Because the 5 days that you have already spent in jail will be used as credit toward your punishment. Therefore, you'll be given credit for the 5 days that you have already served, which means you won't have to serve any more time in jail. Now, however, if they offer 7 days, you serve 5, that means you would have to do 2 more days in jail. Now, every day that you spent in jail also counts as $100 that will go toward your fine and court costs. So if the state is offering you 5 days, offering you a fine and court cost of $500, and you spent 5 days in jail, 5 days in jail is $500. That simply means you won't have to pay any money because the time that you spent in jail has already paid it off. Now, if the state is offering you fine and court costs of $700, you spent 5 days in jail, that means you have to pay $200. Now, if you cannot pay the $200 today or on the day of the plea, then the court can put you on what is called a payment plan. Basically, what that means is you'll be paying off the remaining balance in monthly installments. Now, even if the court puts you on a payment plan, some of you might say, well, I can't pay it at all because I don't have an income. No problem, because the court can convert your fine and court costs to community service. Now, every hour of community service that you do at a nonprofit organization, you will receive $12.50 that will go toward your fine and court costs. So if you work 8 hours at a nonprofit organization one day, that's $100. So $100 will go toward your fine and court costs. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. You haven't been in trouble before. This is your first time. Well, Jefferson County has a DA's office has a program called pretrial diversion. And with the pretrial diversion program, what will happen is they will dismiss your case. You get into the program, you complete the program, then you can get it expunged from your record. Expunged means wiped off, deleted, or erased from your criminal history. Okay, in order to get into the program, it has to be your first offense. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest, and you have to have an attorney to assist you at getting into the program. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County DA's office has another program that is called Veterans Court. That program is also under the umbrella of the pretrial diversion program. What I mean by that is, get into the program, your case is dismissed, you complete the program, you can get it expunged, erased, deleted, or wiped off from your criminal record. And the only thing you have to do to get into that program is to be a veteran of any one of the branches of the United States military. Now, this court has a program that is called the CSI program. CSI stands for Community Safety Initiative. That is the program that I started in March of 2017, within 100 days of taking this office or getting on the bench. And with that program is designed to address the issue of what we call recidivism. Recidivism means where a person commits a crime over and over. And so we address recidivism with the CSI program. And with the CSI program, we have partnerships with agencies in our community. For example, we have a partnership with Spindletop Center. Spindletop Center is our local mental health center. Spindletop, we have a mental health officer, and we also have a counselor here who they're going to come to you and talk to you a little later about the program that they have to offer at Spindletop. And with that program, they would do a private interview, they would do an assessment, and they develop a treatment plan, either outpatient or inpatient, to address your mental health needs. Now, you do not have to be insane or incompetent to be into the program. You could suffer from paranoid schizophrenia, bipolar, depression, anxiety, a whole host of mental illnesses. They'll be able to address those illnesses through the program that they have and through the professionals that they have at the Spindletop Center. If you have an issue with drugs or alcohol, then, well, Spindletop has a program that is called ATAR, and our local drug and alcohol council has a program that is called OZAR. Both programs are designed to address the issue of alcoholism or drug abuse. And the way they address it is by doing a screening, an assessment, and then developing a treatment plan, either outpatient or inpatient, to address your alcohol or drug abuse needs. Now, if you're unemployed, you do not have a job, or you're looking for a better job, then we have a partnership with the Golden Triangle Empowerment Center, and they have a partnership with Lamar University. Lamar University has a program that is called CICE. And CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you select one of those programs that you would like to get trained in, then they will assist you at getting a job in the area that you're trained in. And If you have not graduated from high school, you do not have your high school diploma, they have a program for a GED where you can get your graduate equivalency diploma. All of those programs, all of these programs that I just mentioned to you under our community safety initiatives are free. That means it doesn't cost you anything. Only thing that you have to do is have the time to get into those programs, and that's all you need. You don't have to pay anything. Now, the other good thing about these programs is they all could be used as community service toward your punishment. So for example, I tell people this all the time. You can kill 3 birds with 1 stone. I know people say you can kill 2 birds, but I'm saying 3 birds. And what I mean by that is this. 1, you can't pay the fine. Okay, we converted to community service. And the other thing, where you have a fine, you have community service, and then with the community service, every hour that you do in community service will go towards your fine and court costs. So you're in the program, you're doing your community service, and you're paying your fine and court costs. 3 things, but you're doing 1 thing, but you're getting credit for 3 things. And so that's why I said you could kill 3 birds with 1 stone. And so, as I mentioned earlier, all of these programs are free. It does not cost you anything. You just have to have a desire to be in the program. I tell people this all the time. When you come to County Court at Law number 2, we do not have court as usual. And we have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And we're trying to make a difference in Jefferson County, the county in which we live, to try to make this place a safer place for all of us to work, go to school, raise our children, and raise our families. We do not just give you time. We take our time. So and that means we do not just arrest the problem, we address the problem. We believe that addressing the problem, we can produce productive people. And if we produce productive people, for the most part, productive people do not commit crimes. Why? Because they have too much to lose. And so if you're interested in the program, just let us know. We have brochures here. We have a staff here who could assist you at getting into any one of the programs that you desire to get into. Now, just to recap on that, we have the pretrial diversion program. And in order to get in the pretrial diversion program, it has to be your first offense. You have to have an attorney to assist you, and it cannot be an offense involving unlawful carrying a weapon or resisting arrest. And for our CSI program, in order to get in that program, is free, doesn't cost you anything. It addresses mental health issues, drug and alcohol abuse, job placement in the hotel industry, shipping industry, the chemical industry, and also training. And also you can get a GED. All of those that I've just mentioned are free, does not cost you anything. Only thing you have to do is have a desire to get in the program. At this time, I will have Deputy Hinton. He's with Spindletop. He will come up to you. He's a mental health officer, and he's going to tell you, give you some information about the program that Spindletop have. Deputy Hinton.
Thank you, Your Honor. Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state, commissioned by the sheriff's office. I work primarily with Spindletop. The reason I'm here this morning is because the judge has graciously invited me in here to get a clear clarity on what she has to prevent. What the judge has found, as it's proved, is that we have many issues commonly have mental health, substance use disorder, but sometimes it's a lack of community resources that can help you with your particular situation. The goal, the objective is to get you out of the cycle of arrest. Maybe it's your first time to be here. Maybe it's your 10th time to be here. There's still hope. Like the judge said, the CSI program is geared to help get you out of the cycle of arrest so that you don't have to come back. This form that I passed out earlier is a demographic form. It is HIPAA regulated. It is private. No one will know anything about this information except for us and Spindletop, your caseworker. Should you choose to take advantage of this, there's a place there that if you want to talk today, you can mark that. We will make time for you to speak to you today. Maybe this doesn't apply to you. Maybe it applies to a family member. If you fill out the appropriate information, we will reach out through you to get in contact with that family member and tell them as well. Also, before you leave today, we have a flyer. On the back, it's going to be a little bit about the court program, what we do, some of the advantages of taking some of these options. Also on the front is a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. But everything comes down to decisions. Today, you have another decision to make about where you're gonna go moving forward, the quality of life you want. You can continue in this cycle or you can get out. It works, absolutely works. The judge can attest to that. But we're here for you. If you don't remember anything else I've said today, I want you to remember this. Here to help. If you give us that opportunity. Thank you, Your Honor.
Thank you, Deputy Hinton. Now, ladies and gentlemen, the paperwork that you have, we have our court staff here to assist you if you need any assistance with filling out that paperwork. The court is going to give you time and to fill out the paperwork, and our staff will assist you at filling out the paperwork. You can just simply raise your hand and then our staff will come by to assist you. Now, once you finish filling out the paperwork, if you desire to use the restroom is right outside in the hallway. It's right, if you go next door to County Court Law number 3, that's where the men's restroom is. However, right across the hall, in front of I think it's the 172nd District Court, that's where the women's restroom is. Now, at this time, the court is going to be in recess to give you time to finish filling out the paperwork and to give our staff an opportunity to pick up that paperwork from you and to assist you if you need any assistance. So at this time, the court will be in recess.